E bem-vindas. A Universidade Federal do Paraná tem a honra de recebê-los, mesmo que virtualmente, para a solenidade de abertura do 14º Congresso de Direito do Autor e Interesse Público. O evento tem como objetivo discutir de maneira crítica e aprofundada o tema do direito da propriedade intelectual. Compõe a mesa desta solenidade de abertura o magnífico reitor da Universidade Federal do Paraná, professor Ricardo Marcelo Fonseca, o diretor do setor de Ciências Jurídicas da Universidade Federal do Paraná, professor Sérgio Said Stout Júnior, o coordenador do Congresso de Direito do Autor e Interesse Público, professor Marcos Vachovics. Agradecemos a participação dos servidores docentes, técnico-administrativos, pesquisadores, estudantes da UFPR e convidados. Neste momento, convidamos para fazer uso da palavra o coordenador do Congresso de Direito de Autor e Interesse Público, professor Marcos Vachovics.
Bom dia a todos e a todas. É uma satisfação estar aqui com todos, mesmo que virtualmente, para realizar o 14º Congresso de Direito de Autor e Interesse Público. Eu gostaria de saudar aqui a presença do magnífico reitor Ricardo Marcelo Fonseca, ao diretor da Faculdade de Direito, professor Sérgio Stout Júnior, bem como saudar a todos os nossos participantes, ouvintes e palestrantes que irão, nestes 4 dias, de 3 a 6 de novembro, trocar experiências, aprofundar temas ligados à propriedade intelectual, ao direito de autor e o interesse público. Neste ano, nós fazemos um evento totalmente virtual. E neste meio de pandemia, os esforços se somaram para que este congresso pudesse ocorrer. Eu gostaria de agradecer o apoio recebido pela Universidade Federal do Paraná e pela Unicuritiba, que possibilitaram também, novamente, essa parceria editada. Nesses 4 dias, nós teremos mais de 50 palestrantes internacionais e mais de 80 palestrantes brasileiros. Nós teremos uma mescla de pensamentos que vão somar com os trabalhos apresentados pelos pesquisadores, né? Teremos dentro desse nosso evento oficinas sobre plágio acadêmico, oficinas sobre recursos remotos, né? Porque nós, no meio de uma pandemia que estamos vivenciando, os professores estão sendo convocados numa nova modalidade de ensino que não é nem presencial e nem IAD, e os direitos que estes professores possuem com relação ao fazer em sala de aula virtual. Estudos de caso, teremos oportunidade de discutir o audiovisual, as novas questões relativas ao enfrentamento da pandemia com o streaming, rodas de conversa, e aqui teremos uma discussão sobre as artes em tempos de digitalização e como isso se torna mais acessível para toda a comunidade, destacando também minicursos, workshops dos grupos de pesquisa, que neste ano nós teremos mais de 65 painéis que englobam pesquisadores brasileiros e latino-americanos e europeus. Temos também a satisfação de, no 2º ano, realizar o concurso Apresente Sua Tese no CODAIP, o concurso em homenagem ao professor José de Oliveira Ascensão, onde tivemos também a oportunidade de ter teses e dissertações e trabalhos monográficos. E também, no final, teremos o lançamento das obras dos palestrantes. Este é o grande CODAIP virtual, este é o grande esforço que toda a nossa comunidade acadêmica conseguiu colocar para vocês. Serão realizados nesse evento questões relativas ao acesso ao conhecimento, questões relativas às novas tecnologias da informação e o uso delas no sentido de socializar o conhecimento, de difundir as obras autorais e a cultura. Eu agradeço novamente a todos que se inscreveram e que participam ativamente deste evento. Saúdo especialmente ao nosso magnífico reitor pela possibilidade de realizar o 14º CODAIP. Muito obrigado.
Convidamos para fazer uso da palavra o diretor do setor de Ciências Jurídicas da UFPR, professor Sérgio Said Stout Júnior.
Olá, bom dia a todos, bom dia a todas. É um prazer estar aqui, podendo abrir o 14º CODAIP online, na presença de dois queridos amigos e grandes professores, o professor Marcos Wachowski, coordenador do evento, e o nosso magnífico reitor da Universidade Federal do Paraná, também meu queridíssimo amigo e orientador, professor Ricardo Marcelo Fonseca. Quero dizer para vocês que, como anunciado, esse 14º CODAIP está, de fato, imperdível, né? Eu queria primeiro saudar a todos os professores, a todas as professoras, tanto os nossos participantes nacionais quanto os participantes internacionais que compõem, que participarão do 14º CODAIP. Gostaria também de cumprimentar a todas e todos os inscritos. Gostaria de cumprimentar também, né, de forma muito efusiva aqui, toda a equipe do JEDAI que participou e viabilizou esse evento. E, claro, gostaria de fazer um agradecimento especial ao nosso coordenador aqui, ao nosso maestro, professor Marcos Wachowski, que de forma incansável, mesmo com toda a dificuldade desse ano, monta um CODAIP que eu vou dizer para vocês, é o CODAIP talvez mais pujante, mais importante de todos esses CODAIPs, ainda que seja um CODAIP de forma virtual. O professor Marcos conseguiu utilizar aí, transformar essa situação, que é uma situação obviamente muito triste, muito ruim, né, numa forma de conseguir trazer inúmeros participantes. O professor Marcos me dizia, antes da gente começar a fazer essa abertura, que nós temos praticamente participantes de todos os continentes, com exceção da Antártida, né? Nós temos de todos os continentes, com exceção da Antártida. A gente vai investigar ainda se não tem alguém aqui da Antártida, né, nesse evento, mas temos aqui da Ásia, da Oceania, das Américas, da Europa, um evento de fato absolutamente imperdível, como foi dito, mais, né, de 100 participantes, algo em torno de 50 participantes internacionais, mais de 70 participantes nacionais, palestrantes, né? Enfim, é uma honra, é uma satisfação, é uma felicidade para a Faculdade de Direito da Universidade Federal do Paraná e para a Universidade Federal receber um evento dessa importância. Arrisco a dizer que esse é o evento, nesse ano, mais importante do Brasil e, com toda certeza, também um dos eventos mais importantes do mundo inteiro na área dos direitos autorais e das propriedades intelectuais. Nesse ano, o Congresso se torna ainda mais importante justamente por conta da Covid, né? Muitas questões envolvendo tanto os direitos autorais quanto propriedades, especialmente a questão da propriedade industrial, serão discutidos nesse Congresso. Como os sistemas de direitos autorais, os sistemas de propriedades intelectuais podem favorecer e não dificultar o combate à pandemia, os tratamentos, enfim, me parece que são temas absolutamente centrais, bastante importantes. Queria, então, deixar o nosso registro, a nossa felicidade, de novo, aqui a nossa honra de estarmos aqui sediando, ainda que de forma virtual, esse evento. Eu desejo um excelente trabalho para todos os professores, para todas as professoras, para os pesquisadores, para as pesquisadoras, para os nossos alunos, para as nossas alunas, enfim, para todos os nossos convidados e participantes desse evento, desejando aí um excelente trabalho. Muito obrigado.
Agora, temos a honra de convidar o magnífico reitor da Universidade Federal do Paraná, professor Ricardo Marcelo Fonseca, para suas considerações finais e encerramento desta solenidade de abertura.
Bom dia a todos e todas. Uma grande satisfação estar aqui na abertura desse 14º CODAIP. Eu quero cumprimentar muito efusivamente meus dois amigos, o diretor da Faculdade de Direito, o professor Sérgio Said Stout Júnior, o querido Marcos Vachovics, que é o grande demiurgo desse gigantesco e importantíssimo evento, 14º CODAIP, ambos colegas do setor de ciências jurídicas. Eu quero, inicialmente, fazer esses efusivos parabéns à organização do evento, que, efetivamente, como já dito pelo Sérgio, se constitui, talvez, num dos grandes eventos jurídicos, e não só jurídicos, que se consolidaram ao longo do tempo. Vejam que nós estamos na 14ª edição. Uma 14ª edição que não foi sequer interrompida pela pandemia. E um evento com essa regularidade, sempre com o financiamento público e com essa capilaridade, mostra a pujança, certamente, não só do seu organizador, mas de todas as pessoas envolvidas, da sua comissão e, obviamente, da referência central da importância desse tema, que ano a ano é discutido nesse importante evento. Eu quero, portanto, o professor Marcos Vachovics, fazer esse registro de satisfação da nossa Universidade Federal do Paraná por hospedar mais uma vez e por, pessoalmente, eu estar mais uma vez, como tenho estado ao longo dos últimos anos, na abertura desse grande evento. Mas eu gostaria de fazer um acréscimo, registrando que o fato de precisamente estarmos encetando esses importantes debates aqui na Universidade Pública, nesse momento específico de pandemia, indica, como sempre tenho dito, a pujança, e não só a pujança, mas a centralidade, o caráter estratégico que a Universidade Pública Brasileira, como grande produtora de ciência, tecnologia e inovação no nosso país, tem ocupado particularmente nesses momentos. A pandemia certamente nos mostrou como a universidade, e particularmente a Universidade Pública, é central nas nossas vidas. Que sem universidade, tanto os avanços do ponto de vista biomédico, que agora tanto ansiamos, eles não acontecem efetivamente na nossa realidade, mas não só. Mesmo todos os efeitos que a pandemia acarreta em todos os âmbitos da nossa vida, em todos, eles são, sobretudo, debatidos, pensados e projetados por esse templo do conhecimento, que no caso brasileiro é a Universidade Pública. Nesse caso, especificamente, o professor Marcos Vachovics e esse 14º CODAIP demonstram a centralidade dessa discussão. Uma discussão onde direito de autor, direitos autorais, a possibilidade de livre circulação de informações, numa época em que boa parte do planeta está confinada e boa parte do planeta está ansiosa por informações seguras, por informações científicas, é algo que talvez tenha uma importância que nos 13 anteriores CODAIPs nós não tenhamos visto. De modo que, mais uma vez, portanto, a universidade, nesse caso emblematicamente, cumpre a sua função de difundir conhecimento, de produzir saberes com imensa centralidade e importância para a nossa sociedade. É um orgulho, portanto, a universidade, mais uma vez, contribuir dessa maneira e especificamente nesse debate, professor Marcos, que, repito, tanto nos orgulha na universidade e é tão central na sociedade. Eu quero cumprimentar cada um e cada uma dos participantes, os mais de 50 convidados estrangeiros que vêm de 5 continentes. Quero cumprimentar os mais de 1.000 participantes desse evento online, toda a comissão organizadora, todos os professores brasileiros, mas mais uma vez deixar o meu abraço ao querido Sérgio Stout Júnior, o diretor da faculdade, e ao Marcos Vachovics, o organizador desse evento, desejando que do dia 3 a 6 de novembro todos tenham um excelente congresso. Muito obrigado.
Senhoras e senhores, com o encerramento desta solenidade, desfaz-se a mesa de abertura. Convidamos a todos e todas para a continuação do evento. A programação completa está no site gedai.com.br. A Universidade Federal do Paraná agradece a participação e deseja um excelente seminário.
Angela, microphone.
Hello, Professor Thomas Hoeren.
Yeah, hi. Angela, you need to open the microphone.
Oh, I'm sorry. I'm so sorry. Hello, everyone. It's a great time today here. I see Professor Thomas Hoeren with us. He's going to be in the garden of the Uni Münster in Germany. And so I'm here also, everyone at home within this big pandemic time. And I thank you the presence of Professor Marcos also that's here to say a few words before we start officially. So please welcome Professor Marcos too, and welcome Professor Thomas Hoeren, and welcome everyone.
Professor Thomas Hoeren, it's an honor for us to attend the Congress.
A few words before we start officially. So please welcome Professor Marcos too, and welcome Professor
We have over 2,000 participants in the Congress. We are really honored having been here with us in this meeting. Professor, I remember many times the years I lived in Münster. Thank you to your friendship in the Congress. We are really honored having been here with us. It's very, very, very interesting. I hope everything goes well in your talk. Thank you, Angela, for your also being here. Thank you again for participating in the Congress. Everybody's speech is really important for all of us. Goes well in your talk. Thank you, Angela, for your also being here.
Thank you, Professor Marcos. And dear Professor Thomas, we are very grateful for your participation with us at CODAIP in this very difficult time of coronavirus pandemic. With great pleasure, we welcome you here at the CODAIP Congress. I will say just a few words about the Professor Hoeren. From June 1996 until the end of 2011, Professor Hoeren was a judge at the Court of Appeals in Düsseldorf. He's one of the legal advisors of the European Commission at the Legal Advisory Board on Information Technology. He's also a board member of the Research Center for Information Law of the University of St. Gallen, Switzerland. And since June 2000, he's working as a domain name panelist for the WIPO. In 2005, he became a member of the expert committee for copyright and publishing law at the German Union for Intellectual Property Protection. From 2012 to 14, he was a dean of the Faculty of Law at the University of Münster, actually professor at IPM in Münster. He asked me not to go too far in my presentation or too deeply, and I will obey. So I will just mention that Professor Thomas Hoeren has played and plays an important role in my career, as his work is a great source of inspiration for me. I'm sure that in the period when Professor Marcos had the opportunity to be with him at Münster, he was also able to experience the intensity of his work. You were surely very generously received in Germany by Professor Thomas Hoeren, and we are very grateful that he's here with us today. So Professor Hoeren, once time again, welcome, and now you can speak. We were surely very generously received in Germany by Professor Thomas Hoeren, and we are very grateful that he's here with us today.
So I waited just to have this for your charming remarks of opening. I'm very happy to be here and see you both in best shape. Marcus and Angela have been in Münster, and there was a great chance and great time to discuss various topics, to visit the Kiepenkerl, drink beer, but as well to have marvelous, sophisticated discussions on the future of information. So I want to talk today on a very modern topic, and I will show you my presentation. Sorry, I won't speak in Brazilian, although I love the language. It's the most beautiful language in the world. But I made my presentation, at least in Brazilian, in Portuguese, in order to say thank you to you both for inviting me to CODAIP. The topic is called Propriedade de Dados em Novas Leis de Siglo. So what I want to say, Propriedade de Dados. We are talking about data as the oil of the modern society. Everybody speaks like that. Data is most important. It's the same as the oil of modern society. I totally dislike this metaphor because oil is a very old energy tool which will diminish in the future. So it's very bad to compare data to oil. Data will not diminish. They will stay there, become more and more important, even more important than oil. So, but nevertheless, data is the key element of information society. And we have one easy question, and if we have easy questions, nobody knows the solution. That's a bad advantage. If you have easy questions, they are really hard to answer. And nobody knows a solution in Europe. We are discussing about the problem, and I will show you what it is. It's the easy question of who owns the data. So is there a property right in data? It's very important to know that. Take, for instance, cars. Modern cars from Volkswagen to Uber have millions and milliards of data in them. And of course, to know all these data is very important, for instance, for insurance business. So the insurance companies have a strong interest to get access to this data, but the car producers say, these are our data. They claim a property right in data. And it's not only the car industry, it's every modern part of business using artificial intelligence, big data. So the question needs to be solved in the future. Who owns these data? So, propriedade de dados. We have certain ways of solving the problem, and I want to show you what is discussed in Europe, at least, for these propriedade de dados. When I talk about Europe, I don't mention the United States or Japan and China. I feel that the discussion is going on in the United States. I'm not too aware about China. They have made a new copyright law and a new data protection law in China. but I haven't heard of Chinese researchers who have investigated in the property rights of data. So I have a very European view. The first instrument to be used in that discussion is the database directive right. That sounds very, very good for Europeans. We have made a directive, so every country in Europe has integrated in their copyright an element called database right. So, of course, then everybody said, oh, that's solved. We have solved the issue. We have a new right in every European country, database right. It's a very fascinating new right. So it's a protection for a limited time, 15 years, for collections of data. And you only need to prove that there was a substantial amount of time, money integrated in this data. So it's a quite easy right, a little bit strange in copyright law. It has nothing to do with copyright, but it's good. Sounds brilliant for the information society. But we have the European Court of Justice who made two decisions, and correct decisions, who said this database right is only there for databases. That means for the structure of databases, for the investment in collecting, arranging, and structuring data. It's not a new property right in data as such. It's only a kind of formalized right for the investment in the structure. So the Direito de Banco de Datos will help not at all. So then we are coming to the Direito a Proteção de Dados. What you have in Brazil now, the data protection right. So I welcome very much that Brazil has integrated the data protection rights, the privacy rights in a new statute. And I'm very happy that Marcos has published even an article on my view of the Brazilian Act. I'm not so sure whether we have understood everything correctly, but I try to tell in that new book he has just published how Europeans have a view on the new Brazilian law. So we are happy. We have the European general regulation on protection of data. And again, it sounds brilliant. Everything solved. We have our own system of protecting data. And what is the problem? But that's typically German. We always have questions like, but the problem is, it's only a protection of personal data. So it's only there if you can prove that a natural person has certain problems with the use of his data. And therefore, we have made the data protection, or as Americans call it, privacy right. So it's only there if you can. So that's one element, one reason for but. The other reason for but is it's not a property right, it's a protection tool against the misuse of data. So you cannot say somebody owns data. It's not giving an exclusive right it's only an exclusive protection right. And third part, many data of which I'm talking about are raw data, that are data without any personal links. Take a car, take a Uber. The data of a certain Uber car using gasoline is not a personal data as such. It's a machine data. So the protection of data as such is not addressed in data protection. Although it sounds like a good tool, it's not solving the issue. Then we have the third solution, propriedade in general, the general property concept. That is a very bad solution, and insofar as property law is different in every country. We have property laws in Germany, different from France, different from Brazil, different from the United States. So it's a very complicated, puzzling world of property law. So, but nevertheless, let us simply check general concepts of property law. We can say dados como mercadioras. We say in English, data as goods. We have a concept in several international countries of goods can be regulated by classical civil law. Are data dados mercadioras? That's the question. So in Germany or in Switzerland or in Austria, mercadorias only consists if they are tangible goods. Goods means you can grab them, you can really have them. That doesn't work at all because data are intangible. So then we have the second view, data as part of tort law. I think the translation is very bad. Derecho civil is too general. So of tort law, perhaps data can be part of the discussion on traditional tort law. But tort law, nevertheless, is only applicable if you have tangible goods. So if you delete tangible goods, you are punished under civil law by the question by tort law. That doesn't help at all. Now I'm coming to a third view. I had that third view 10 years ago. I tried to take elements of criminal law, of penal diritto, and use it in civil law. So it's very bad in Germany to say, let us have a look at penal law and use principle of penal law in civil law. But I did it. I said, have the people from criminal law solve the issue in criminal law. And they had a solution, at least in Europe. They said, we say data belongs to somebody who has technically produced them. So they have a theory of the originator, the technical writer. It's somebody who is responsible technically for writing data, gets the protection under criminal law. And I had the vision, they might be very clever to use that concept in civil law. The problem, however, was criminal law will never be used even in an analogous way in civil law. And it's a concept too broad to say everybody who is technically writing data gets a kind of property right in data. Who is the person who is writing data in an Uber car? Is it the car producer, or is it the driver, or the person who's owning the car? Who gets the rights? So I'm already skipped that theory, and I made another one that is called, we call it in English, law of possession. We have property law distinct from possession law. And why can't you say simply to be the person who is the possessor is the owner of the data? It's not the full range of property law, but in Germany law, the person who is possessing data gets a minor right compared to the person who is owning data. So I was a fan of that 2 years ago, but now I skipped that theory as well. Why? Simply is to say that every person who is factually controlling data, every person who is the possessor is the property owner, is too broad. There need to be some normative element to justify giving him exclusive rights. And there's a last theory, bens de dados is de necessarios. That means it's totally important as a rubbish discussion, as an unnecessary to have a property of data. That is the feeling of most people who were involved in this discussion. They said, it's such a horrible, nasty discussion. Stop it. Data should be free. There should be no right, never, not in property law, not in possession law, not in database law. Stop it. But I have found the solution. Of course, German professors always think they have found the solution, although we need some time to say it was rubbish. I think the solution is the lex de sigillo. And there was a very, very important man in Germany, almost forgotten. His strange name is Seligson, and he wrote a book in 1921. It's almost forgotten. You have the difficulties in finding that in Münster Library. And he's written the book on Geheimnisbesitz. He called it Geheimnisbesitz. Besitz means possession, and Geheimnis is secrecy, and he calls secrecy a special variation of the law of possession. And he tried to find out which elements of law of possession influence the concept of secrecy. It's a fascinating book. I've read it 100 times, and I think it was perfectly right, even 100 years ago. And what makes me believe that he was right is a new development in Europe. There is a new directive of the European Union called the Directive on the Protection of Know-how and Commercial Information. So a new directive protecting secrets. This directive has been implemented in almost every member state. I think only Cyprus has said no, but almost every member state has implemented that directive. Even I found that you in Brazil have become a fan of secrecy laws because you have you have made an act in 1996 on the protection of secrets. In the directive, there's a mentioning saying every data is protected if it is secret, in the sense that it is not known to everybody, and it has been subject to reasonable steps under the circumstances by the person lawfully in control of the information to keep it secret. So these data are protected by secrecy laws, and they are protected by the directive in a very broad sense. There's a new regime of claims of rights given to the owner of the secret. He can prohibit the direct use of secrets, the indirect use of secrets. There are good limitations of the rights for whistleblowers, for reverse engineering. It's a very good directive in balancing the rights and interests of the public. And I believe this directive is a solution. If the car industry wants to say, these are our data, and you don't have the right to use it as an insurance business, they can simply do everything foreseen for making the data a sigillo, for making it a secret. And then they are protected to the utmost, but not to the utmost, because there are limitations, special limitations foreseen in the directive for protecting interests of the public. So I'm investigating in that interface between secrecy laws and law of possession and data law. I'm not sure whether everything works. I would definitely like to hear your opinion about the matter. So if you don't want to talk to now, you can send emails. I will, of course, answer every email you send me, and you'll find wonderful information on our website, www.itm.nrw. So you find articles where I've published all these matters. So, obrigado, thank you very much for your attention. I hope you liked my talk.
Professor, it was a great talk. Thank you very much about secrets.
So, obrigado, thank you very much for your attention. I hope you liked my talk.
In the time here, because you are in German and here in Brazil, so we have a small time about secrets. Thank you very much. If you have a question in the chat, maybe I can. We're in German and here in Brazil, so we have a you. Question is, what is your opinion, Professor Thomas, about monetization strategy of your personal data, maybe as a way of protecting privacy? What is your opinion about monetization strategy? What is your opinion about
I need to wait in order to get 3 times her voice heard. Now I have the nice music of so I understood that you asked what is my opinion on personal data as a protection tool for personal data under privacy law. As I said, I'm really a fan of data protection. As I'm a German, you know that Germany is a mother country of data protection in the world. We are the eldest nation in data protection. So we did everything we could. As I'm a German, the problem with data protection is are the United States. And I think we can easily build up a coalition against the United States regarding their bad behavior. For instance, regarding in the privacy in the international context. And I think we can easily build up a coalition against the United States regarding their bad behavior.
Yeah, okay. Professor Thomas, we are hearing a sound, stranger sound, but maybe, can you hear me now?
Yeah, it's very bad. I try to hope that I understand.
Yeah,
It sounds like a samba bar in Brazil.
Yeah, it looks like that. And I thank you very much for your effort with your Portuguese. It is really great. But I'm afraid my German is better, yeah. It's really good. It's really good. You told me, you told us in the beginning that you don't like to compare that data with oil. May I ask you if we can say the same about creative works? Sometimes compare also with oil. In the beginning, you don't like to compare that data with oil. May I ask you if we can say the same about creative works? Sometimes compare also with oil.
Yeah, I don't like the oil metaphor because it's always used in the context where people claim new property rights. And that's very bad than to compare oil with data. It's the same people who always say intellectual property. You know, from Germany, I simply said when we had a talk, never say geistiges Eigentum, because this kind of metaphors like intellectual property are so misleading that we should avoid any metaphor at all. And that applies to intellectual property, and that applies to oil and data. Intellectual property are so misleading that we should avoid any metaphor at all. And that applies to intellectual
So this was my next question about intellectual property word, this expression. You used to say in German that you don't like this expression at all. So you anticipate my question, and I thank you very much for that. I was Anna has a question, and you already answered. And I don't see any questions more. Someone has a question that I'm discussing my question, and I thank you very much for answering, Hoeren. Or I was Anna has a question, and you are answer. And I don't see any questions more. Someone has was there. Gehört der Herr Professor Thomas Hoeren. Vielen Dank, dass Sie sich die Zeit genommen haben, heute mit uns zu sprechen. Danke.
Very good. Sehr gut gemacht.
I hope we can see each other in a better time without coronavirus, with all people together one time, maybe in Minster, maybe here on CODAIP, Curitiba, with all people doing questions together. But now we are in this way and we need to take care of everyone. Better time.
Yeah. And see you in Münster, of course, next time.
One time. So I thank everyone for that session, for being here. And now we will then close this section. You have a lot of works. Next time, the works continue in CODAIP. Please take the
And if students have questions, they can easily send me an email. I will answer all emails.
Yes, thank you for saying that, Professor Thomas Hoeren. He will always answer the emails, so don't lose this opportunity to talk with you.
Okay.
Thank you very much, Professor Hoeren.
Yeah, okay. So bye-bye.
Bye-bye to everyone. Finalizamos, será? Deu tudo certo. Atenção. I would like, Anna has a question, and you already answered, and I don't see any questions more. Someone has a question that I'm seeing my question, and I think you will or I would like, Anna has a question, and you already answered, and